So thank you for joining us. This is still our special coverage of the verdict declaration of the SRC Court of Justice. Now, in some few minutes' time, the justices will be ready to give their verdict on the election. Just like I said earlier in our first live, that there were four cases which the justices presided on, and they are going to give the verdict today. So let's now take you to the medical hostel and see what people are saying on campus. This is a big issue. I mean, we are on campus this time, and then there is a court hearing. Last year there was something similar, but we were at home. So this time we are on campus. So my colleague Benedicta is at the medical hostel at Trafalgar, and she's joining me on phone call to tell us what the situation is like there. What are people saying? So Victor, good afternoon to you. And what can you tell us about the situation there? What are people anticipating? What are people saying about the entire court hearing?
Okay, I'm at the medical hospital currently, and I have a few people here I would like to talk to. Hi, please, you're live on you have this. My name is Deborah. Okay. Have you been following the court hearings about the SRC, just ended SRC elections? Okay, actually, I haven't really been following. But you've heard about it. Yes, I have. And what are your thoughts about it? Okay, I think it's a good initiative to ensure that peace reigns and then everyone is satisfied with the outcome of the election. So after the hearings, what are your expectations? Okay, well, expectations are everybody be treated fair and then the truth is pleased where it is supposed to be. That's my expectation. Thank you. I have over here another lady I would like to speak to. May I know your name? Yeah, I'm Mabel. Have you been following the court hearings about the just ended SRC elections? Not really, but I know what's going on. That the case has been taken to the High Court, and then they are doing something about it. Yeah, I think. Okay. So, what do you think about the whole thing? The whole thing, I don't know, but then for what is going on, like I hear this people saying this, this is saying that. I think everything should be done well. I think the court should treat it fairly, because it's an election, and then it's our right. It's our right to have our right to seek free and fair elections. So I just hope that the court will come out with something good, and then something good that will please everyone. Yeah. Thank you, Mabel. That's what people in the medical hospital are thinking right now about the whole court issue. For now, we'll end it here for now. I'll get back to you with more thoughts from people from the medical hostel.
Okay. Thank you very much. That was Benedicta, our correspondent at the medical hostel here in US, one of the new hostels. So I'm being joined in studio by Kenneth, who is going to help me with the studio analysis of the entire court proceeding. I mean, this is a big issue with so many things to discuss and digest today. So we'll first talk about the whole verdict. I mean, what people are saying, what we are all anticipating and everything. So first of all, what do you expect to happen, or what is your ambition or expectations this afternoon?
All right, thank you very much, Mr. Zinas. This whole issue has been interesting and a learning process indeed. We have learned a lot, right, from how that the petitions were circulating on various social medias, and people were expecting that the Chief Justice goes around looking for cases to actually come and preside on. We think that it has been a learning process for us all. It has been really educative and interesting for us. But right from where one of the cases were thrown out from the court through to the three cases that were presided on successfully, and we are here to look out for the verdict. I think that the CJ has been one of the trusted people, of course, and then we expect that it should be constitutional. It should be something that we all are expecting. It should be something that the Constitution is saying. We do not want a situation where people will have different thoughts, people will have doubts that are in the Constitution. We want the Constitution to actually speak for itself. And then this is not the first time we have trusted him a lot of times. He has been on various boards and we trust his integrity and we believe that today we're going to have the best of verdict. We're going to have that is in the constitution and nothing at all.
Well, as you know, there's so many possible outcomes today. There may be access to revote, there may be revetting, and so many things. But then let's take the issue of revoting. It's almost getting to examinations. Students, in fact, exams have been suspended. So let's assume that we're still writing exam. Do you think that people will still be interested in this whole court process?
All right, thank you very much. This is a very broad issue that has actually come up. But first, if they should be revoting, is it something that has been constitutionally instituted or is it something that has been logically instituted? That is something that we need to understand. What are the petitions from the petitioners? How did they actually argue their cases? What did they see? And what are they also talking about? Well, from what the students of UHAS are saying, a lot of things happening on the social medias and all other things, they just want the truth to be done. And if you are saying that we should do re-election, how is it going to be? One of the cases were like the process of the election were flawed. And so if you are going to do re-voting, how is it going to be conducted? What manner is it going to be conducted? Are we going to use the same way? If it was about money or software developer, how are you going to do it? So these are some of the things that we are going to consider in the revoting. Is it going to be the same thing as previously? Are we going to adopt a new mechanism for that? Or we are going to use a new model? This is something that we need to consider. And the people of US are already frustrated with the whole issue. And so what we need to understand is that we need to actually go by what the constitution is saying, what the petitioners presented to the court, and how it was presided on. So people of US are ready for what is good for them. But at the end of it all, what is best for the US SRC? If we are to do re-voting, are we going to use the same thing that people were saying it was flawed? Are we going to go by another software that is going to cost us another money? Or how are we going to do it? That's a big problem that we need to consider. Because after all, it is something about the US SRC and the student body must be concerned.
Yeah. So you notice that over the years, there's always, in fact, it's like every year there is a court hearing. Every year, there's happened last year, a couple of years happened. So US has been using an online voting system for quite a long time. Could it be that the problem is actually with the voting software and not necessarily other factors? Because if last year there was a court hearing, this year there is the same court proceeding about the same credibility of the voting software, and people saying there have been so many rigged elections. Is it possible for us to have a ballot? Because balloting comes with so many challenges and so many things. Here on campuses, even people leaving their hostel coming here is a big issue. So if we opt for balloting system, I don't think we'll get a high turnout.
Okay, this is a very good one, of course. But what you need to understand is that the word credibility in elections, so far as several parties are concerned, is subjective. All right, the word credibility, so far as several parties, different parties in the election are concerned, it is very subjective. How that one will say it is credible, how that one will say it is not credible, is something that is very broad and subjective. But the way forward, what is the best for us to use? We have tested a lot of things. We have tested the software. We have tested the online voting and all our things. And we have seen how far we fared with. We have seen how we actually fared with, how far we went with that. And still people are complaining. But it is still inevitable for complaints to come because even in the national level, where ballot papers are used, where this physical asset and all our things are used, people still complain and they are still court hearing. So in both cases, it is inevitable for court hearing to actually come in. And the complaints of the people are also subjective depending on where they are coming from. So this case is a very broad issue that we need to talk about. I have showed you even why even in the balloting one, people still complain at the national level and at all other levels where they are balloting, people still complain. And even with the online one too, people are still complaining. So the best thing we need to know is that if you have a problem with the election, if you have problem with the election, even without evidence, you should come and argue why you think that it is flawed and we cannot continue with that. But as to you proposing another model or proposing another way of voting, it is going to have the same impact on the people, because you have seen it working in several dimensions of the voting processes and in the election processes across the country. So the ballot issue has its whole problem. The online voting tool has its problem as well. So we cannot actually weigh the biggest difference or the biggest disparity between them. But what we need to understand is that so far as one has come out to say that, okay, fine, I have a problem with this particular voting, then they should evidently argue out why they think it is flawed or why they think it is not flawed. That is what is important. But as to proposing another model when we do not know why we should forego or forsake the current one, I think this is something that we must take a second look at and work on it very well.
Okay. Well, if you're watching us on Facebook, do well to leave your comments. What do you think? Tell us your thoughts and everything. But then their argument is that there are big countries in the world, United States, the United Kingdom, many countries, even in as much as they have technological advancement, they still use balloting. So Ghana, in fact, national election use balloting. So what is preventing us from using balloting? Now, in the constitution, it says that the online voting has been tested and the benefit outweighs the risk. So they are saying that if the government of Ghana uses balloting, all these big countries, why don't we just shift to the balloting? Because that is what everyone is doing. That is what majority of countries in the world do.
Well, as I early on said, even with these developed countries that have sophisticated mechanisms and other things that can actually enhance their voting processes using this ballot, they still have these challenges that they are also having. You understand what I'm saying? They still have these particular challenges that they are facing right over here. But I remember when we were in the house, we opted for the online voting because that was the best option. So far as everybody was at home, that was the best option.
Yeah.
So if people of you guys are saying, if that is what they are saying, and from my perspective, they have tried the online voting, they have seen the cost, and they want to do with printing of papers and all other things that can actually be involved in the online voting, be involved in the balloting as the physical voting, then there should be a way for them to actually try. But what are the ways that they can push in? How are they actually pushing in with their thoughts? That is what is important. You cannot go out saying, as I have already said, people are expecting the CJ to go out fishing for information, fishing for cases to actually come and preside on. That is not what we need to do. If you think that this is something that we need to do, bring it on board and let us wait.
Okay. Yeah. Right. So thanks. So we are still at the court here. Where just in about some few seconds, the justices will be entering the court hall to begin the verdict declaration. Like I said, on Monday there was a court hearing here in Gilhas on the election where there are 3 cases relating to the election. So in some few minutes, the justices will come in and begin to declare their verdict on the election. We had 4 cases, which I read earlier, 4 different cases about the election. With the first case was dismissed as having no merit, while the second case was challenging integrity. So we are all rising as the justices come in for.
You're live with US Based TV. I'm Zena's our main headlines.
The SRC Court of Judicature is due to announce its verdict on the election petitions and all other cases it heard last Monday. One of the cases was challenging the credibility of the voting software used for the election. Another case was to nullify the result of the just ended election, which was petitioned by an aspirant, Moro. And the big case everyone was talking about.
So like I was saying, kindly put your phone on silent. You'll be out of here in no time. Okay. So once again, good afternoon and welcome to today's court hearing. We had a court sitting, and today happens to be the judgment or the verdict declaration day. I'm sure the parties involved are all here fairly represented, either by themselves or by their attorneys. Please, I hope all the attorneys or all the petitioners or feuding parties are around. We don't want a situation where we call for a particular case and the petitioners or the attorneys are not around. In that instance, the bench will be forced to pass a judgment in their absence. Okay, so like we said the last time at the court hearing, for case number 1, I'm going to read all the verdict and what actually transpired in court, give a case summary of the case, then give the judgment per the results from the bench. Let me hasten to once more add that the composition of last court hearing, we were 6 justices. However, myself as the Chief Justice, I was only serving as a presiding judge. I had no voting right, and for that matter, my other 5 justices had the voting rights. Even though in the course of the court hearing, I was presiding or I was the chairperson, once again, I had no voting right. And me being the Chief Justice was to see what really transpired at the last court hearing. Unfortunately, 3 of my justices are not currently in Ho. That is how come you are seeing just the 3 of us. 1 is in Ho and 2 are currently in Accra on an equally important business. So that is why you are seeing only 3 justices today. So quickly, I would want to move to case number 1. So in the Superior Court of Judicature of the SRC Court of Justice held on Monday, the 9th of August 2021 at the Ho campus at the New Medical Block C03 before His Lordship Chief Justice Yeboah Kwame Isaac at 1400 GMT. Case number UHAS JC 21001. So the applicants or petitioners are Mr. Mesu Washington and Mr. Japon Akrasi Stephen. So introduction and case summary. This document hearing referred to as attention, a contempt against the UHAS SRC Court of Justices was submitted by Mr. Mesu Washington and Mr. Japon Akrasi Stephen on the 7th of August 2021 and was duly received at 10:46 p.m. by the Chief Justice. The document seeks to draw the attention to a supposed contempt act committed against the Court of Justices of the UHAS SRC by Tim Sunny Days after the SRC Court of Justices injuncted the declaration of the presidential results on the 6th of August 2021. The document further states, and I quote, "We humbly implore the court to, as a matter of urgency, act on this contemptuous act from the said team." unquote. This was our judgment. The bench, in a unanimous decision, declares that the case be thrown out of court on grounds that it doesn't merit a court hearing. As stipulated in the 1992 Constitution of Ghana, in the Article 126 themed composition and mode of exercise of power of the judiciary, when you read a clause 2, it states categorically that the superior courts shall be the superior courts of record and shall have the power to commit for contempt to themselves and all such powers as were vested in a court of record immediately before the coming into force of this Constitution. This is to say that only the Court of Justices has the power to commit for contempt to themselves and not any other person else. The Court of Justices, however, has taken note of the attention raised by the party of Mr. Mesu Washington and Mr. Japon Akresi Stephen of a supposed contempt against the IHAS SRC Court of Justices, signed by myself. The quorum were myself being the presiding judge, Justice Mary Opon Mafo Ajwa, Justice Gagbe Charles Nukunu, Justice Lawrence Denue, Justice Jennifer Owusu, and Justice Agbesi Evelyn. So this was the case 1, which was thrown out of court. And we have given reasons why it was thrown out of court. Okay, so before we move to the 3 remaining cases, Justice Lawrence would do a brief judicial education so that even as we are giving the verdict for the subsequent cases, we are all going to be at peace and not have any shred of doubt in us. So at this juncture, I will let my justice have the floor.
Good afternoon once again. And as stated in the court hearing, we stated that the bench, after hearing the case, the suit by Mr. Emmanuel Kwabena-Boateng, titled A Suit Against the Electoral Commission, found it necessary to give a brief or detailed education as to who a running mate is, the position of the vice president and its linkage to the candidature of a presidential aspirant, as well as the qualifications needed to ascend the throne of the office of the vice president. So when you read Article 51A of the U.S. Constitution, it states that the Court of Justice shall have jurisdiction in all matters relating to the enforcement or interpretation of this Constitution. And it also goes to say in Article 50, Clause 4, that without prejudice to any provision in this Constitution, the decisions of the Court of Justice on matters of interpretation of this Constitution shall be final and conclusive. So the recommendations that we made was that all court judgments or all judgments by the bench on electoral disputes be added to documents for handing over by the EC. So anytime the EC hands over any judgment that has been passed by the U.S. SRC court, be added to it to stop any reoccurrence or a case or revisiting a case. Also, the public elections instruments or regulations, or the public elections regulations, that is the constitutional instrument 126 of Ghana, of the Electoral Commission of Ghana, be added to the document for handing over. So now, let's go to the running mates, the presidential candidate, and the office of the vice president. So let's start with Article 37 of the U.S. SRC Constitution, which is themed elections of executive officers. It is stated that a student shall not be a candidate in any election unless he is nominated, underline word, nominated, for election as president or secretary or treasurer or women's commissioner by a document which is signed by him. B, signed by less than 10 students from each JCR in the case of a provincial executive officer, or at least one student from each JCR and at least 2 students from each school in the case of a federal executive officer. C, be delivered to the Electoral Commission on or before the fixed date for closure of nomination in relation to the election. So when you look at nominated, when you look at the regulation, the Public Election Regulation CI 126, sub regulation 7, or regulation 7 of the CI 126, it states that whenever a president, that is the D, let me read it verbatim so that's 126 7, the one to do with one, two, six. Please. No, this is not the constitutional instrument. There. So constitutional instrument 126, regulation 7. Which regulation 7, which is team nomination of candidates in presidential elections. Nomination of candidates in presidential elections. It goes on to state that the nomination form of each candidate in an election for president shall be signed by the candidate, be signed by not less than 2 persons. C, designate a person to serve as a vice president. That is our focal point in that regulation. It must designate, the nomination form must designate someone to serve as the office of the president. And this also is reiterated in our constitution under the Schedule 7. Schedule 7. Schedule 7, Regulation 1B, which states that whenever a presidential, when there's a cause for a presidential election, the nomination form must provide a column for a vice presidential candidate. So this is to say that whenever there's election of a president, whatever document that is the nomination form that is to be given to the presidential candidate must provide a place for a vice presidential candidate, which is the running mate of the presidential aspirant. This is also stated in Article 62 of the 1992 Constitution and Article 21 of the US SRC Constitution, which I quote, a candidate for the office of vice president shall be designated by the candidate for the office of the president before the election of the president. And when you look into our 1992 Constitution, there is a whole article on how the election of the president is done. And it's, when you read that part, you also find out that before election takes place, there must be a designated vice presidential candidate. This means that in the election of a president, this means that the election of a president legitimizes the election of his or her running mate as vice president, even though he or she is not a direct contestant. Contestant in a sense that the person's face is who you see on the ballot paper. Even though you don't see the vice presidential candidate on a ballot paper, whoever you vote for, in case the person wins, is legitimized as the vice presidential, as the vice president of the election or the country. That is stated in Article 60, Clause 4. And I read, A candidate shall be deemed duly elected as vice president if the candidate who designated him as candidate for election to the office of vice president has been duly elected as president in accordance to the provisions of Article 63. That is Article 63, which I stated earlier, is that the whole article has been designated for election of the president. So now let's come to the qualifications, or what one must have in order to hold the office of the vice president. This is also to state that whoever the running mate is, what qualification the person must have in order to be deemed a running mate or to deemed a vice presidential candidate. So under our constitution, under Schedule 7(1)(b), it states that, I've stated it earlier, nominations shall be filled in respect to the post of the executive officers of the SRC, to wit, president, secretary, women's commissioner, and treasurer. The nomination form for the president shall have a column for the name of the vice president he or she intends to appoint in the case of a federal president, who also qualifies, underlined word, who also qualifies to be elected as an executive officer. So when you read Article 18 of our US SRC Constitution, it states which people are called as SRC, federal SRC executive officers. And I quote Article 18 of US SRC Constitution. The federal SRC executive officers, there shall be 5 federal executive officers, to which the president, secretary, and the treasurer, and the women's commissioner elected under this constitution, and the vice president. So when you go back to our Schedule 7(1)(b), which says that the nomination form of the president shall have a column for the name of the vice president he or she intends to appoint in the case of a federal president, who also qualifies to be elected as an executive officer. So the election of the qualifications of a vice presidential candidate must be linked, or is linked, to that of a federal executive officer. When you go to, so what are these qualifications? Under Schedule 7(2), which is themed qualification for the post of executive officers, it states that qualifications for the post of executive officers under the constitutions are contained in Chapter 6 of our Constitution. And Chapter 6 starts with Article 37, Article 38 of the U.S. Constitution. But more specifically, Article 38 gives the qualifications required by an federal executive officer. And I quote Article 38(1), which states, a student shall not be qualified for any executive office. And we all know any executive office includes the office of the vice president. And any executive, so he or she is attached to a hall or block of residence. B, he or she is qualified to contest elections under his hall, hostel, or block's constitution, except that a provision requiring a student to spend at least 2 academic years in the university shall not disqualify such a person from contesting for any office under this article. And C, the one in contention, he has attained a cumulative grade point of, or CGPA of 3 as at the time of filing of his nomination. So when you read at the 1992 Constitution, the Article 63, it states that according to the Article 62, I'm quoting Article 63. It states that Article 62, and Article 62 refers to the qualifications of a president of Ghana, who is qualified to be a president. The article underlining who qualifies to be a president. It states, so the Article 63, which is for the vice president, states that Article 62, qualifications of a president, applies to the vice president. So whatever qualifications that must be met by the president must also be met by a vice presidential candidate for the office of vice president. So according to Article 21(3)(b) US SRC Constitution, the vice president may be as part of his function. So now let's come to functions of the vice president and why there's a need for him to hold the qualification of a federal SRC president. So according to our Article 21, the section for vice presidency. It's at clause 3b, which states that the vice president may be called as part of his function to act in place of the president. When so acting shall be vested with all the powers of the president, subject to the provisions of this constitution. So if you do not qualify to be a president, you cannot wield the powers that the president have under our constitution. So these are one of the reasons why a vice president must meet the qualifications of a federal SRC president. And when you go to Article 32(8)(a), and in the previous hearing, the bench stated that the reason for giving a column for the vice presidency is that the spirit of the constitution is in line with the saying that 2 heads are better than 1. And when you look at the value or the premium placed on the president, it is so huge that one person cannot fill that role. So when you read Article 32(8)(a) of our constitution, which states that in the case of impeachment of the president, the vice president acts in his stead in the sense that he substitutes him automatically. This implies that so there's an implication here. So provided a vice president did not have the qualifications of the president at the time of elections, he or she cannot hold the position of the president once the president has been impeached. So this is to do or give credence to the need of a running mate to have met the qualifications stipulated by the Constitution under Article 38(1) for federal executive officers. So for the avoidance of doubt, under Schedule 7.4, the other regulations that guide our elections, I'm reading. A person can be deemed a candidate only after he has been vetted purposefully by the Electoral Commission. B, a person put up as a candidate may withdraw his candidature before the start of the various face-to-face as in vetting, before the vetting, face-to-face. So at the halls or hostels, a candidate who by the start of the face-to-face commence is yet to put a campaign poster shall be deemed to have withdrawn his candidature. A candidate who wishes to withdraw after the face-to-face may do so formally in writing a withdrawal letter to the Electoral Commissioner, and any such withdrawal, however, shall be granted on the terms that the Electoral Commission deems fit. That is 1. A candidate cannot withdraw his candidature a week before the voting day. No candidate, his representative, nor supporter should campaign whilst voting is in progress. There shall be no campaign with material within 100 meters radius of the polling station on the voting day. And H, complaints of electoral fraud and the allegation of electoral malpractice should be lodged with the Electoral Commission within 24 hours after voting. So all these regulations under sub-regulation 7.4 are regulation 7 sub-regulation 4 applied to the vice presidential candidates. So now to do with the issue as to if whatever happens to the vice presidential candidates affects the nomination of the president. Now, we know that by our human rights, we have under this constitution of Ghana, we have the right to vote and to be voted for. So whoever picks a presidential candidature form is in line with it. Whatever he does is in line with his constitution, and he's responsible for his actions. And whoever he nominates is also responsible for his action. Because when you look at the constitution, it says that whoever the candidate is must sign. And the signature that the vice presidential signs in the nomination form, which we have here, is not as a form of endorsement as other signatures in the nomination form is. So when you take the nomination form, there are 2 types of signatures you find here, or 3. You have the one by the candidates, which the president signs. In terms of the presidential, the president signs, the vice presidential also signs, and the EC signs when the nomination forms have been accepted and gives dates and logs everything into it. So when you read CI 126, CI 126 Regulation 9, and it is themed nominated candidates. Whenever the nomination paper and statutory declaration of a candidate are delivered and deposit is paid in accordance with this regulation, the candidate shall be considered to stand nominated unless proof is given to the satisfaction of the returning officer, which is the EC, of the candidate's death, withdrawal, or disqualification. The returning officer shall inform a candidate that the candidate's nomination is invalid. I take it again. The returning officer shall inform a candidate that the candidate's nomination is invalid, where A, the particulars of the candidate or the person subscribing to the nomination paper are not as required by law. 2, or B, the nomination paper is not subscribed as required by law and so there's also a caveat, and shall give that is the returning officer shall give the candidate an opportunity to make amendments or alteration necessary within the stipulated nomination period. So whenever a presidential candidate submits his nomination form to the EC, the returning officer, if there is a problem with any part of the nomination form, if it is before the deadline day of the deadline day for filing of the nomination or submission of the nomination form, the EC is allowed or is obliged to give it back to him to make any corrections. I hope you all understand this. So with this, I leave the floor to the Chief Justice to make the pronouncements on the various electoral disputes brought before the bench. Thank you.
Okay. Thank you very much, Justice Lawrence, and I hope we are all clear now. Okay, so moving to case number 2. Of Justices held on Monday, the 9th of August 2021 at the whole campus, the new medical block C03 before His Lordship, Justice Yeboah Osei Kwame Isaac, as a presiding judge at 1400 GMT. The petitioner was Mr. Isaku Moro. Pardon me if I'm not pronouncing the name well. And petition to nullify the local NUCs and SRC elections held on the 6th of August 2021. These were the court findings. The court found out that the software was insecure. And we are using our words very carefully, insecure in quote, since it allowed for a 4-combination number to open other students' voting interface. However, the software was proven not to allow for voting, even if one had access to the voting interface of another student using the 4-combination number. This was the ruling by the bench. Majority of the bench concluded that the petitioner was unable to prove that the breaches in the election software led to rigging of the election, and all the anomalies stated in the petition had no statistical significance on the election. Hence, the bench in the 4-1 vote decides not to nullify the entire elections. The no vote gave the reason that the insecure nature of the system did not merit a total rerun of the election. However, the EC should put in measures to secure the system in subsequent elections. Signed, Yeboah Osei Kwame Isaac, Federal SRC Chief Justice. Quorum, Yeboah Osei Kwame Isaac, Presiding Judge, Justice Mary Oponmafo Adjoa, Justice Gagbe Charles Nukunu, Justice Lawrence Denweme, Justice Jennifer Owusu, and Justice Agbesi Evelyn. We move on to the third case. Let me also add that copies of the judgment will be made available to the the fielding parties, as well as all students of UHAT. It will be sent via our student email address, copies made to the Vice Chancellor, the Provisy, to the Office of the Dean of Students, as well as to the registrar.